We are still on a year the suspended Chief Justice. The suspended Chief Justice Ninsem so far made the 2 stories are bremo on a year issues are already na me hune say in the comments box enya asem ketwa Ghana fu bebre na no comment so. Before we go, let me say this. Mr. I have launched my very first book. And now me name say the hard copy of the book. So what hard copy no book na nkasa say obenya book na nkasa won same as paper form na wo bie mu na wo kenkan no. Eno no ye nyan wie ati ase. Na me hune say sisi ano I have released the ebook. Ebook na me release no. Mo amonti ase no ebook no say obenya book no wo phone so na wa kenkan. Nti ene no enye hard copy say on sabe kan book no. Ba wo be download the book no na to phone so ni we bie wo phone ne so na wo kenkan book no senia ende document ya Chief Justice ni statement no on says Chief Justice statement no ono no kita ne paper no kan but ye nya ne electronic version and I making kan atremo nti senia making kan Chief Justice document is na obehu book no so wo phone so na wa kan nti I know ye the ebook. Some people are complaining because say link na me de to ho no there was no mobile money payment option. Mr. Remo, I have worked on that. It is a person wuchia auto book no na okay kanya. Ni mobile money there no link no our comment box ni mo. You click the link in the comment box and then mobile money you pay 20 cedis and then the book will be downloaded on your phone and then you read the book. Mr. Remo, a book on my journey on how I lost weight. Senya me to me losing me weight from 130 to 100. Me lose 30 kg in 3 months. Enyama me ye enyama me sua. Me the old pictures ni new pictures. Ato ho ama wa wo behu. Senya na me fute. Senya sisi a me fu aba beye. Eni bibia wa wo behu. Enyama me ye enyama me di ye. Bibia eyemya me story. Ena me dia ye book no. Inte me sra mo se utie me na o struggle with weight loss. Opeso living healthy krana ebia you are not struggling with weight loss but opeso living healthy krana link no ewo comment box in the very first comment, click on it, 20 cedis, you download the book, make sure you read it and give me your review. Please read the book, give me your review. It's as simple as that. Now quickly yan concept ni mu inti say baby a ye do ye ewo ye mama Chief Justice in semno emu no. We were telling you the na worker send your worker say irregularity. Them say you do baby and worker say irregularities. Now the recap and they say we've done 2 videos on it already. Wakanin Sem her problem and all that, and we've also responded in our own light. Me who say in the comment box some of you are getting angry at the Chief Justice Amoka say na ma say na not in same way na no can the and all that. Into no more most more kasa no more. But let's continue reading the statement, no, because we want people to understand the full context. What you say, yen to me read the kakrebi keke emfa emba mbeto. Now, baby I do you know any or say odu baby no waka say committee no na say they have been compelled to subpoena. What you say, baby no waka say I say the petitioners no ya mom to me say wo monko frɛ nkrofo mba no mom na be common nsɛm ni bi mom and all that, and she wasn't happy with that, you know. Yen to aso say because the proceedings are being conducted as if it is a normal litigation between the petitioners and my humble self, that is Daniel Ofori versus Gertrude Torkornoo, or Shining Stars versus Gertrude Torkornoo. Now before I continue, let me make a correction. I'm say Momo baby are correcting me say the Edu Lodge, you know, it's not the same as the Osu Castle. Musi Edu Lodge, you know, say it is close to the Osu Castle, but it's not the same. It's a mistake now. Mose Mayano, Mr. Monfanchame. Anyway, yeah, let's continue. I say because the proceedings are being conducted as if it is a normal litigation between the petitioners and my humble self, i.e., Daniel Ofori versus Gertrude Torkornoo, or Shining Stars versus Gertrude Torkornoo CJ, or Ayamga Akogo versus Gertrude Torkornoo CJ, contrary to the procedure which governs commissions of inquiry, the petitioners have their respective counsel who direct what evidence the petitioner wants to show the committee. This is also in violation of known rules regarding proceedings of a committee of inquiry regulated by CI 65, under which a committee of inquiry ought to have its own counsel to ensure that once the committee starts proceedings, the petitioner becomes no more than a witness for the committee to prove the allegations that led to the setting up of the committee of inquiry. They ought to testify on oath for the committee and be cross-examined by the respondent, who is the subject of the proceedings. Now, I have said, what can I say? Once she was raising concern about say adia no say a commission of inquiry. Now so it is a court. I said a litigation. It's in Groffono the lawyers about women so all lawyers cans and the sense of modium lawyers about na it is a court litigation in Groffono lawyers bar. Evidence our more person no more tre. Meanwhile, and there was a heading echo. Then again, all I'll tell you and say these are issues that we raise in front of the Supreme Court. And the judges, in their own wisdom, are born same. But here, my message, Dabi, or Bagana for him, and the Ababe to yenim. Because apparently, judges no, Sebe, a dream near Mutrim, or Moonim the Omoye, our Mobon same guye. So they be 2 yenim, yen a yen one yansa, essing judges no Omoti Supreme Court or. So the 2 yenim, near whom said judges no Sebi or more bon. I don't know, but. Comments back on me reading and back on they say, okay, so now that you are telling us, what do you want me to do? I say, okay, so now that she has come out to do the press conference and she's telling us all these things, what does she want us to do? Oh, be some mammy say, mammy, this year, then opposite, yeah. Young couple judges, nana. I say, in this case, the public officials served with applications for subpoenas to present certain documents, swear oath, and present the documents to the committee as exhibits. These witnesses themselves do not have the petition. They do not either know the allegations of the petitioner or may have heard of them from social media and cannot speak to the allegations. When they finish submitting their documents, my lawyers are called on to cross-examine the witnesses. Since 23rd May 2025, this strange process has been followed and witness after witness has been called. Like Nebuchadnezzar's situation, in which he demanded that the magicians in his court should tell him his dream and also interpret it, my lawyers are left to guess which allegations in the petitions I was given, in the petition I was given on 27 March 2025, are the subject matter of the testimonies that the witnesses have referred to. What is important to state is that the High Court rules, CI 47, never conceived that any hearing will be done without the claims, defenses, and issues to be tried being carefully laid out before the parties and accepted by both parties. In this case, there are no agreed claims, no agreed defenses, and no agreed issues that the inquiry is supposed to establish. Ladies and gentlemen, it is this total absence of compliance with all known rules of fair hearing that has caused my lawyers to file applications for judicial review in the High Court to declare all the proceedings void. The clear danger is that in light of flagrant violation of CI 47, the very rules the committee claims to be using, and the darkness of the committee proceedings being held in camera, my lawyers and I can come to the end of proceedings. The evidence will show that every allegation in the petitions that were given to me by the President on 27th March 2025 is unfounded and untrue. Yet, the Article 146 committee can dig up some allegation from whatever documents they claim to have received from the President, which they have not shown to me, and purport to enter a recommendation for my removal on that basis. Allow me to say to the nation that what I am reporting on is a situation that is totally unknown to the rule of law in this country. If it was lawful, I would have no reason to alert the nation of the dangers they represent. It is the clear and blatant violations of law that have forced me to bring these matters out in the light of day. Now, Oshe in some way, she has confirmed, say indeed, she has filed a judicial review in High Court. In TCCI, they were called High Court, were filing another case. Or they are called High Court. Atiasie. Or file judicial review in High Court. So that's what she's saying in this paragraph. Now, ladies and gentlemen, it is the total absence of compliance with all known rules of fair hearing that has caused my lawyers to file applications for judicial review in the High Court. It is here they will when they say High Court on or also call and Supreme Court. The Supreme Court will can call ya. Say India man no. Sisiano. Say or kasa based on the human rights. Say fairness being in Yama being koso ewo a honti or call High Court. And that this all we were asking for. In some way walking in ano, the ye bisani, you know what to do. So why is it that Oba Ghana for him as a Oba Babesiki a public sympathy? So she has filed and she's going for the High Court. And she's going to the High Court. But you see, I personally come in. Okay, so this is what she's saying. I see petitions no committee name function in some committee ne catch and wakasa same way. Committee name country and say in some way ye raise no any committee in someone can say you already have the petition. You requested for the petition from the president. It was part of the process. In fact, it wasn't even part of the process. But it sounds like we requested yanunti. The president gave the petition to you. It is that same petition a ye hunjuma. And so if you come and you say yenfa petition nema yenfa mawa, we don't understand what you are trying to do. But you have the petition already. Those were the things you responded to. Until now she's talking and saying, say, President ne petition na ekra committee no mpanyimfo no. And no more allegations na committee no raise. Ono who petition no omo de we president na send petition na man de, but the omo edi, and so she wants to paint the picture as if say a different petitions altogether na president no sanso de akwa committee no. Meanwhile the same petition na president no de man no. It was say raise allegations from those petitions. Committee ni raise allegations from those petitions our no ni mu hwenti akwa say as the indirectly no person tell say ye the same ni bribri. So meanwhile she knows the issues already. I don't know. So what I'm trying to say is say if she obviously has seen the petition because the president sent the petition to her. If committee na no petitions na a war committee no enim allegations na wo mo raise tiane no, if she feels say a different from petition na president at the man now, why is it that she's not mentioning it? I don't know whether you understand what I'm saying. Because president no the idea now. What about committee name say committee no so far the same thing now. Say president need the amount that didn't you over say yen so ye the amount. He say who raise the issue say it sounds like committee name for wo mo de emma won ntino. In sem na wo mo raise allegations na wo mo raise no. I said there who nim ho hwe. And what I'm saying is say it sounds like president so e the amount who nim de what president need the nim no. And there's a committee no so ba be raise ne de. Na se wo hwe na se ensem a wo mo raise ne ni president need the nim specifically no kan ye ntie. Ana de make won tie ase. E dia president need the ne yesi we wi asika. Committee ni de no mo koy no mo se da bi we kun nipa. O se eh mesramo petition na president ne ma me no sisika na me wia. Mo de na mo kan de mo se ye nipa na me kun te mesramo. We de mebo a. Se ne de wo kan ne hu ne say indeed. Petitions ni different. But you are not saying anything like that. You are not mentioning the differences in the petitions. You've read and responded, but you are not mentioning the differences in the petition, but you are just using that as more like a route to claim say a illegality on you. And your mom person member petition no petition ne kan me hu ye and ye me hu ye. In some no mo raise no if it is different, tell us. Tell us. In some no, say nya sa, catch ye. Ana me bodam. Etiefo. Enya sa na etia onka. Anyway, I say effects of the current proceedings. I say the final and fourth reason for the statement is that I have heard on several occasions from loved ones, persons who care, persons who may not know me beyond my public duties, and many who think that since it is clear that the current proceedings seem to be carefully staged to result in my removal as Chief Justice, it would be best if I just retired or resigned rather than subject myself to an ill-motivated process. I have also received threats and veiled threats to the effect that if I fail to resign or voluntarily retire, I will be made to suffer some harm or the other. Into asemo worker, and they say, sa current proceedings here, it is having a toll on her. It is having some effect on her. Now, effect on any say nkrofo air threatening no. Nkrofo air ka thre no. Say one retire, omo beye ne bone, omo bedi ne bone. Into yon resigning. Or say I have also heard several commentaries in the media about how this process was born out of a stated political agenda to remove me and control the judiciary, and that it is a political effort that can only result in the charade of a hearing that is played out. I thank all those who have engaged in a conversation out of concern for my safety and well-being. Let me assure everybody that I do not seek to cling to a title or position. However, as a lawyer of 38 years standing, a judge of 21 years standing, and Chief Justice of Ghana who has served in the rule of law all of my working life, I consider it my onerous duty and obligation to speak up concerning the administration of justice in this country. The situation I have been confronted with has shown me a model of injustice that I would never have thought possible if I had not been exposed to it. This is why, despite great personal discomfort, I have decided to marshal every effort in law and leadership to answer to this situation. Now, just like the chairman of the NDC said, it is very serious that she's alleging, say people are threatening to attack her. Someone, suspended Chief Justice, no. It shouldn't get to that level. Or more threatening someone by attacking, no. Obviously, probably maybe she received the message, or probably maybe they sent her email, or they told her in the face. I think that it is time for her to report to the state security. Unreported to police. Obia was your person causing a harm, biano. She shouldn't be telling us. A serious matter. We live in a country where we yenye hundia too a ametwali. Inti sende, we a public figure. No be threatening wa. Don't sit on it. Report to the police. Inti mesre mameno unreported to the police. Ose mwa ka mwa kebia mani ni nano odamonso ase. Waye jumache. Waye lawyer 38 years. Mwa ka se wonya no nkonko tena ni baby ndwene ho no. Ose enu hu nti. Yamfa ade weye ndina. Na ko won hu se Ghana ye judiciary ni mu no. Sebe nkrofo bi ewo tumi a wo mo etumi de yeden edidi nkrofo so. Hey, ye mame. Kaza na ngo say, "Hey, Melodies, ade na woka say ye mame." Chale. Yamfa nye na nko wonim. Yamfa asem we ndina nko wonim. Se bibi wo reasumu say. As a furthermore, resigning or retiring while Article 146 proceedings are being conducted to remove a judge is not an option any judge or public official is even allowed to have. Now, person resign krana adie no enye option. See ye probe near your investigation on to mean kasa resign. There is a decided case on the subject by the Supreme Court. The suit number is J602 2019. Said case bi wo hosa judge bi ni ye no ye the article 146 and na ye di judge no judge ni ye na adwen say or resign ye ka kire judge ni say untumi resign inti na mami no onim say article 146 no ye di yi judges and na wo ka se said ye eye precedence a NC da mami ni mo The second point I want my yen in say idea where ya de yemi, a bin see that ne yenimia de yemia, ye de beya other people, a fufro, ye de beya judges for front my and penny and fine yameno. And that ye do say, ye say resign, no say, oh, say case be crowd or hot that. Ah, and also ye judge be sir, na ye judge, na judge ne ye not say war resign it. Judge ne ye not say war resign it. Into ye no. One call. Oh yes, not just so resigning. Ye no, Supreme Court Emma ruling na ye cast dabi only who can so be resign. And the dear, what can I say? Into ye judge be sir. The article 146 na yi sa judge no. And when the what kind of woman? Jesus Christ. I say again, no one has the authority to walk away from proceedings started by the state. Judgment can be entered against you because you failed to defend yourself. And a judge who resigns or retires will still lose all entitlements because they failed to defend the claims and resigned or retired while the proceedings were going on. It may only say a lot of people are using this side also against her. I mean, fair enough. For me, I don't see anything wrong with this. Or see, another thing they say, Okas or resign here, ni entitlement ni nano, ebe shure no, entitlement ni den, ni pension. Because when you say, Supreme Court judges, no, they go on pension on their salary. If you ever say at the end of the month, 30,000 cedis, and a wunya emra woye juma, or call retirement, sa 30,000 cedis na no benya. What you say? They are very privileged. I'm not going to lie to you. They are very, very, very privileged. Inti, or since or call retirement na, sa ne retirement benefits. Ebi a lamp sum bia ye debe mano, and then the pension sika ni nyamano, o nya sa nyamano. Inti mo amoka say inti mami say ni sika no wodwun ni sika. Chale ene dia mesre mo. So why ye juma? Why judge for 30? Why judge for so many over 20 years? Inti we tell the benefit, the pension benefit na oba be lusu a. Wo anka ho pene. Inti ene dia mesre mo. That side there. Mo amu use against her no. Mesre mo. Ene dia munya no. She has the right to her retirement benefits. Also therefore, if false claims are made against a judge or any commissioner or other public office holder subject to Article 146 proceedings, just to achieve a political agenda, the solution cannot be to resign or voluntarily retire out of frustration, pressure, or fear. One would only find themselves being subjected to two cruelties: a judgment based on false claims and loss of everything that one has worked for. It may well be the efforts. It may well be that efforts are being made to make me feel frustrated and resign, so that the architects of the scheme can go back into their media to say that the wild and unfounded allegations in the petitions were not defended because they were true, or that I had no credible defense to them. I see a bit to me about say, omo shetia omo peso mu yi no efri ho no. Omo a na eye. Omo peso mu ya no mu yi no. Omo yi na no mo asan akwa tina TV so. Anomo peso be defending ne ho. Me resign me kokko resign this is here na. Mo na mo be san so akwa tina TV so say ah see ye kan e. No nim say we di boni ni nti na wa ma me defending ne ho e na wa resign nti eno hu nti on resign. As Chief Justice of a nation who has been given the onerous duty and obligation to lead administration of justice, I should not turn tail and run when I know the implications of not defending false and unwarranted charges. If I resign under these circumstances, I will be saying that this flawed, unknown, and opaque process is acceptable. It is not. Or resign here, a better say, wajiatum, sa dia yede ye no no, yemfanye obi foforo. Any kwansi yede obi, on jintum, into on resign. They need to protect Ghana's institutions. Also, ladies and gentlemen, let me say respectfully that the current bizarre proceedings I have brought to your attention presents a twist to our nation's democratic journey that we ignore only at great cost. My humble view is that Ghana has come too far in the 33 years of the Fourth Republic not to be alerted about the unconstitutionalities around these Article 146 proceedings that seem designed not to affect just me personally as Chief Justice, but all judges and public officers subject to Article 146. If it is successfully carried out without being questioned, Behind me is every judge in the country. Behind me is every commissioner or head of an independent constitutional body in the country. If this model of removal can be tried on the Chief Justice, it can be repeated with everyone. I am not countering these processes for myself, but on account of the leadership burden I carry. If the nation is willing to accept these developments, it must be understood that I sounded the warning and the nation took the decision to be passive about it. I cannot share the burden of those involved in designing and implementing this enterprise of pretending to use Article 146 procedures to remove a Chief Justice through unknown and unlawful means by keeping quiet about the violations of law, rules, and due process. Neither can I make their burden lighter by resigning or retiring, instead of proving that not even one of these wild claims in a collection of petitions is even remotely true or meets the standard required for removing any judge. Or say, idea way AC, o jinemu ama judge se wo Ghana krumha. Judge, a judge for ni ne wo Ghana krumha no jinemu ama a judge for. O jinemu ama the commissioner na ahase ne na me say onim say jinmensa de ba intino o kan o jinemu ama commissioner of Ebia Isine Sashraj ne Sankrofoni nina. Ojinemu ama all independent constitutional bodies. Say, some model of removal ya yedi the Chief Justice. See anhwe ni ye ni epene ni ede ye na omu nina ebetumi yi omu nso. Then again, why is the Chief Justice acting as if this is the first time someone is being removed with that article? She never made this stance when Daniel Domelevo was removed by President Akufo-Addo. She was a judge. She never said this. She never said this. When Charlotte Osei was removed, she was a judge. She never said this. Osei was a judge for over 20 years. When Miss Lamte was removed, she was a judge. She never said this. When Judge Derry and the likes, they were sent through Article 146 judges. We didn't hear her say these things. Why is she acting like this is the first time? Ye judge be and ye commissioner be Ghana ha. Worker says, dear with the man sorry na menjina. A chinebi, ye the baba be ye commissioner. Ye the baba be ye we, ye the be ye we. What's now Chromham ye the young crow for one cassa? And that they will say also ye jina because some person the other people. It is not precedence. I say the three petitions. The petitions which are being used to inquire into why I should be removed from office have been in the public domain for some months now. They are actually available on the internet, so I'm not addressing anything that is not known in the public space. Many negative things have been said about me through public commentary on the petitions, although the petitions were responded to 7 days after I received them. And so anyone who cared to acknowledge my side of the story would have no need to keep repeating what it is in the petition. What is in the petitions without discussing the answers. When I provided responses to the petitions, I explained with evidence that each allegation was either a lie, a wrong opinion about how work is conducted in the judicial service, a wrong opinion on the work of judges, or a wrong opinion on the duties of a Chief Justice. I see 3 petitions now. They are to so in somewhere. What petitions ni name no. And try ni ye twa to ne so. Omo mo petition. Omo nim se ni judge se dwumate. Omo nim se ni Chief Justice se dwumate. Since somewhere ye kan ni na ye ntro. And I think at this point, yeah, mommy should put her trust in the colleagues now or more Supreme Court judges. You see what she's doing or what she's saying. She's painting the Supreme Court bad. So is it that she doesn't trust in the colleagues? No, Supreme Court judges say they don't have the integrity to be able to know Say a intro ni ye twa to ono maame ne so ana. As to whether a intro and say nye intro, that is the essence of the committee. People don't understand say committee na nyo omo adwuma ne say rightly no omo beka say maame no we di boni o. Committee na adwuma ene say omo behwe say ensem a ye de ato so as a chief justice na ye no kware ana say nye no kware. And so say oh Bible nti aba beka say ensem ni na ye intro, but you are speaking as if say ade ne kra no ye be pame o kra na tre say oh ka say o judges menu na ti case ni so no omu di intro ommepene so ne etwa intro ato so. Do you know what it means? It means say obi eye innocent no kokko gina Supreme Court judges enimu a o pese o try say there is a high possibility say Supreme Court judges no ebe chi nipa krona tum because do you know the dangers in some way like do you understand what I mean? And bibian sesan judges na na Supreme Court no eyamo President His Excellency John Dramani Mahama won fa new judges in bayo afiansa ya 37 new ono ne 7 new judges a omokra no wonya nso e wo mu in tini new judges ne kran ko Supreme Court omo ntumi nkonko di case ati se oso e wo mu in inti judges e wo Supreme Court no eye wo maame wo judges na judges ana oni omo ye adwuma wo Supreme Court omo a. But today all of a sudden you are speaking as if say judges no all of a sudden as say omo ni integrity biom omo ntumi nhu no kware enhu intro. Are we safe in this country? Then it is a major reason why we need a reset. It is a major reason why we need a reset in our judiciary. If even the suspended Chief Justice does not trust 2 judges and the colleagues, case we so, then tell me, don't we need a reset? Indeed, we need a reset. Don't try your comment box in the moment I say.